Oh, good morning and welcome to Supreme Court Update and Litigation Roundup. My name is Thomas Burles and I will be the day coordinator for the session. I have an announcement before we begin. Please remember to silence all cell phones. The CLE code will be provided at the end of the session. If you must enter or exit while the conference is in session, please do so quietly. I will now pass it over to our discussion leader for the session, Jennifer Coakley, AILA Business Litigation Attorney, Government Relations, Washington, D.C. Mr. Staff, we all have to get our pictures taken. And of course, Brian Green, who's been an incredibly good leader in the litigation committee this past year, and we're looking to service this year, also a well-known litigator. Topics. I'm going to play a couple of roles today. My first one is report on AILA litigation briefly, and then what we've done is gather what AILA I believe are the most interesting and the cases that are hitting hardest right now. So once I talk about the litigation report, we briefly discuss the standing, and after that, Brian is actually going to be talking about nationwide injunctions, and Ira is going to cover incredibly interesting material, including recent developments and Federal Tort Claims Act, and pretty much everything else. So briefly about AILA litigation this year. In March, many of you probably know that there was a change to basically all of the USCIS forms systematically being done every few days, changing the forms with no grace period, which basically would mean that our members would be filing applications, which would then be sent out. So we acted very quickly to file litigation. Brian participated on this team, and maybe others as well. I'm not sure, it's your baby. But anyway, we had good fortune there. After filing the complaint TRO, and we did get relief. I wanted to thank again Banak Pelkey. Okay, sorry about that. I wanted to also wonder again for serving as a plaintiff in these cases. It's easy to be a victim. Our current cases at this time include a challenge to the registration requirement, which has been very intense. We're working with great partners, and AIC's involvement is the lead partner. There are several other organizations who are involved, including the ACLU, NILC, and the Art Rights Project. We had all been looking to litigate this case and found each other and are working together. So we brought this case in the DC circuit on preliminary injunction, and that's all we're talking about in more detail. There's a huge campaign right now relating to standing, and in particular, there's an interest of many in the judiciary that maybe standing is too broad and that it needs to be narrowed. And in this case, a very narrow idea of standing was applied. So we lost the first preliminary injunction on standing, and we have since refiled in both courts. And in fact, this time, standing was recognized, but still not for the organization, but for the associations. But it was found that there was no, if you can believe this, irreparable injury when millions of people are being required to register at all kinds of risk to their freedom. But still, there was finding that there was no irreparable injury. So we now are on another complex procedure course of action in both the trial court as well as the appellate court. We also have had going for a while, very important case on Afghan humanitarian parole because of policies that specifically disadvantage those in the most danger, which are those who are still we're at this point, we're working on posing a motion to dismiss, and we'll be proceeding hopefully to class certification thereafter.
Jennifer, where's that case pending now?
That one is in Boston. Yep, thank you. And the ILRC fee rule, litigation from Trump 1.0, that's still at a low level, kept alive because we're concerned that they will try to change the results of that litigation, which is a temporary, well, which is a preliminary injunction, without going through the proper steps of ruling. So we're basically just keeping an eye on that. And finally, AILA and American Immigration Council, most likely early next week, are going to be filing a FOIA litigation on the adjustment of status pause. We asked for documents quite a while ago and none. And also, I hope many of you will consider coming to AILA's Federal Litigation Conference in Las Vegas, Nevada on July 22nd and 23rd. Registration is now open shop. And I can tell you, Brian and I, and many other topic leaders have been working to put together what I think is going to be a very meaningful panel, including some. I think you'll find that these days it may be necessary sometimes to do some frick appeals like we face. We're really surprised to have to face. And of course, AB is another. So I'm moving on now to my assignment for today, which are some of the standing cases, the one that most of us know about, but just a reminder, and as well as some strange things happening in Florida and elsewhere. So Food and Drug Administration versus Alliance for Democratic Medicine, as you know, came down in June 2024. But I just want to remind everybody that there was a pretty big change there. So what they said was basically the party line that this is so they used the party line that the Supreme Court had been using for a while, which is showing a diversion of resources. And that's consistent with, cases from the past. Several of them, most of them in immigration law have been using the diversion of resources for the organizational law theory. So, and then that goes all the way back to the Havens Realty, when Havens Realty was sued on housing discrimination, was when that first came out. But SCOTUS was reading Havens a little differently now, saying that their interpretation of that same case from all those years ago is that really it was based on the direct interference with the organization, which was the organization this home, with home's core business activities. So, and then they said that's not dissimilar to a retailer who's a manufacturer for selling defective goods to the retailer. And honestly, I'm seeing more in Supreme Court cases this movement toward we're only comfortable with like business concepts. But this is a really significant change. I have to show that it affects a core business activity. Interestingly, several circuits have said, right, that's what we've been doing forever. But it's actually not, because the diversion of resources is what has been going on forever. And we think that it's very likely, depending on who your judge is, that you will find that the district courts are going to require a robust showing of interference with the core business activity. And that just happened to us. And in the requirements, the registration requirement litigation, where we had both the organizational and associational clients, and we had to replete everything. We did every conceivable argument that we could. We're pretty comfortable. He once again, he found the association standing, but he many. Yes, it is. But we did not make a standing barrier. So thank you. So this is, to me, this is the strangest development. This new, if you're going to check, is what I'll be touching on, but it would apply seemingly to rules or other meaningful challenges. Maybe the judges will decide to cover only the named plaintiffs. And we have this drama going on in Florida right now. It seems like there's a new statute criminalizing basically being an immigrant. So the first one is the older of the two. And it's called Farm Workers Association. At this point, the defendant is Meyer, who's the Attorney General of Florida. And these cases so far have all been found to be preempted by federal law.
because they are preempted by federal law. But what's interesting here is how their Attorney General Osmeyer and his attorneys have been able to make the fact that it's preempted basically meaningless. And I'm going to explain that, not 100% meaningless, but there's a sort of dramatic chronology here, in my opinion, that I have not seen in Southern District of Florida. So Judge Altman, a good judge, heard the case in May of 2024, May 22nd. The same day, he issued an order saying, yes, this injunction will apply safely. The very next day, he's strangely, after entering an order, said, you know what, I'm a little confused. I need a briefing on whether this should just cover the plaintiffs only, which that would mean you could arrest anyone else except like the individual. Okay. And so he asked for all this briefing, and strangely, it took quite a while before the next ruling was in 2025, actually 2023. Same judge entered an order, and now instead of being statewide, 3 individual plaintiffs, the Farmers Association, and the members of the Farmers Association. And then a few days later, Judge Altman recused himself from this matter. The case was reassigned. A motion for reconsideration was filed by the plaintiffs, and a little bit later, the new judge, basically it was the same ruling, which again, 2 more, so 5 individual plaintiffs, Farmers Association and its members. The law is preempted by federal, it's preempted by federal law, and basically anyone else is now still subject to this because they're not plaintiffs in this lawsuit. And this was actually what I was primarily going to look at. We had a lot of trauma in a closely related case, or this statute from the following year, which is Senate Bill 4C, which I believe is even more draconian, and that it criminalizes anyone who ever entered without inspection, who got over, who transferred, who crossed lines into Florida, regardless of their status. So it's very draconian. This is before Judge Williams. Judge Williams entered a statewide injunction, and this was recently, and Attorney General Osmeyer refused to enforce it. On June 17th, Judge Williams found Osmeyer in civil contempt, and Osmeyer was already appealing that to the presumably shadow docket, his contempt ruling. So you can see that that's a very significant change in standing. Another case, which is it's a strange case because it really focuses, in my view, on did you choose the right defendants. It's a 2024 case. It's called Murphy v. Missouri. Here, Missouri, Louisiana, and 5 individual social media users sued just the government agencies and individuals who presumably, as they pled, were harassing the social media platforms to monitor misinformation about COVID-19 in the 2020 presidential election. And so then this was basically a First Amendment case, and Judge Amy Barrett ruled. And there were 2 things that she did here. One was not really as relevant to standing, which she was just saying, you know, future really. So you're going to have to meet a higher standard. That's going to hurt you. So that was the first thing. The second one was, you're saying that the government should not be in contact and encourage these moderate practices, but we know that they were already doing some moderation. Because the case they got into trial, I think it's discovery. There already had been some moderations. How do you know that it was caught? You know, not surprising that she said that we usually don't rule against the proper party is not be to enjoying the actual platforms. You always ought to enjoy the government agencies and officials, and in fact, just basically the whole trial rulings were vacated. There was a finding there was no redressability, which is whether the defendants named could actually solve the problem. They can't, then they weren't the right defendants. And what I found particularly interesting was what combination do you have to establish, in order to name the right defendant? And of course, there's not an answer to that question, but it's one that everybody needs to look at and decide who all to name. And finally, I want to talk about a slightly older case that's being used increasingly by the courts, which is TransUnion LLC versus Ramirez. which is a 2021 case. This is the case that was a very the first ruling in the registration requirement, the alien registration requirement case in DC, that was the basis of finding no standing in the first iteration of the injunction. So in this case, an auto dealership was using the credit rating agency TransUnion, and it wasn't really being very careful. So there's a list of Office of Foreign Assets Control of known terrorists and other criminals that they were basically had not carefully matched the names and sort of made sure the names were the actual people on the list. And so Ramirez went to buy a car, he had a lot of people with him. He was told basically, you're on this criminal list, we're not going to sell you a car. He contacted some attorneys, a very significant class action was brought, and went all the way to trial, lots of discovery and damages. And it was a huge class action because, like I said, that's one of the major credit agencies, reporting agencies, and they had not been very careful. So potentially affected, but basically only 1,853 of those people have proven up that a third party definitely got their information. So everything was reversed except for those 1,853 people who could prove up that they were, someone was told that they had this inaccurate criminal activity. And the essence of this case is concrete injury. But it also goes on, and this was, I think, important. This was also used against us in the, like I said, in the registration requirement case, because it basically goes on to talk about what the harm versus that you have to show that it essentially is a very traditional class action. You have it to the end. I think most of us do that, but I think it's more of an issue than it has been. And also the underlying issue here was like the concreteness, the immediacy of the harm, right? So, and this was a final ruling. It's not just not to have standing, and that was what was also ruled with respect to the many people who should that we are still, and that I think brings me to seeing this over this structure to my friend and the leader in litigation.
Jennifer, one of the questions on the online app is if you could give us the full case names of the cases that AILA is party to right now.
Sure.
But some of the remote people want to have the actual, I don't really need the Westlaw site, but
Actually, I mean, maybe I can do it at the end because I didn't include the full sites.
you can use the party.
Okay, right. Okay, right. So for the rule challenge, the plaintiffs were AILA, and this is for one make sure. You remember the one? It was AILA. For some reason.
I'll go ahead and you can look at that. We can change that during the Q&A. It's CIS. It's the main party because it's easy to find them. It's my privilege to be here with Jennifer and Ira Kurzban. Obviously, it's my honor to see so many federal litigators in the crowd, and I think I've co-counseled with maybe a dozen so far. So it's an exciting time. We're very important, obviously. Habeas is an area that I'm doing a lot of habeas right now, and I don't think we're making a lot of money off of habeas. It's not a gold mine, but we're getting people back to families, and we're getting people back to jobs and employers. So it's my privilege to talk a little bit about the Trump versus Casa birthright citizenship case. I was able for AILA to listen to the oral argument. I think it was about a month ago, maybe a month and a half ago, and Jeremy McKinney, former AILA national president, and I wrote a really good AILA Think Immigration blog piece on it. So I'm not going to go through all the details because it's already out there and you can get it with your membership. But the nice thing I thought was, and the challenge is only a very narrow issue at the Supreme Court right now. The Trump administration knows they're going to lose on birthright citizenship. They did not appeal anything on the merits. They're appealing only the judge's nationwide injunctions. There's 3 different groups of states involved here, but essentially the conservative justices are looking at reining in nationwide injunctions. We don't want to have judges in Seattle or judges in San Francisco making these nationwide blanket rulings. But the attorney general from New Jersey made this brilliant argument. He came out and said every year, 6,000 babies are moved into New Jersey that were born somewhere else in America. Are those children not eligible for Medicare? Are they not eligible for Medicaid? Do they not qualify to go to public school? Can they not get, the essential, records that they need to have to function in society? So he was saying, well, if there's a Third Circuit decision or if there's a Pennsylvania only injunction, how does New Jersey as a state, how do they operate their institutions when we have state by state citizenship? I mean, we've not had that. This is a federal system. So the AG from New Jersey did a great job. And I think to contrast that, we have the DACA case in the Fifth Circuit, where the Fifth Circuit upheld the state court decision saying DACA is illegal and the employment authorization is illegal. So now we have the weird example where DACA is for penalty provisions. DACA and enforcement is working everywhere in the country. But if you want benefits, DACA works everywhere except for Texas. So we have one state where DACA federal law does not exist right now. And that's, I think, what they're looking at with the Trump versus Casa de Maryland case. We probably will have a decision in the next 2 weeks on that. So I think if you want to, and you have time on your airplane, ride home, read the AILA Think Immigration blog piece on it. And then when the case comes out in 2 weeks or so, you'll see how nationwide injunctions are going to be treated. And I think that's going to be a big part. Ira's going to talk about the shadow docket or the Trump docket. And I think it's getting harder and harder to see how we navigate standing, how do we navigate TROs and injunctions. But it's going to be a time when more and more valuable as the litigation bar.
And I think it's a really interesting interface between what both of you have been talking about, which is standing and injunctions, and you can see it in the birthright citizenship case, because if they decide, for example, that the injunction only applies to an individual who's before them, then the Trump administration is free to start taking away passports of everyone else in the country because they don't have standing and the injunction hasn't affected them. And that really is the brilliance of why they brought it to the court in the way they did, because they understand that if they can limit an injunction, then they can just run roughshod over everyone else in the country, because not everyone has the money to hire a lawyer. Not everyone has the capacity to fight these cases, so they can just start doing what they want as a policy matter. So those people don't have standing in terms of what Jennifer was saying, and the injunction is very limited. So it's going to be interesting, I think, right, Brian, to see what happens and what they do with the injunction or not, because it is going to have an effect one way or another on birthright citizenship. Okay, so if you don't mind, I'm going to stand up. It's just an old habit from practicing law.
Yeah, go ahead.
Okay. Are these on? I don't know.
Yeah.
Okay. Yes. Yes. Okay.
We apologize for the audio problems in the first 15 minutes of our session, but Ira's going to be nice and loud for everyone, especially those who are not attending but listening in right now.
Let's see. Can I don't know how to do these things? Oh, there we go. Okay. Okay. On February 20, 1932, declared national war in Germany. Franco was practicing law in Germany at the time and continued to do so until he had to flee the country in 1938. He wrote this period that was ultimately published in the United States with the help, ironically, of the United States, a former president for whom Steve. The book is titled The Dual State. It's a little difficult to, for those interested in the subject, it's philosophical, it's about what happened. It's a very interesting book. Franco tries to explain in this book how under fascism, the courts and the legal system operated on two areas. One is called the normative state, the other is the prerogative state. I bring this to your attention to understand the framework which now operating, particularly as immigration orders, and with particular reference to the Supreme Court and the things that it was saying, taking people to El Salvador to a prison without a foundation and so forth. In the normative state, the courts function as they always have, deciding cases based upon principles. In the prerogative state, the government, despite being subject to laws, exercises its political authority to engage in political acts that it and its party officials are found to be beyond the jurisdiction of the courts. So he states in the book, quote, it's the complete abolition of the availability of law as the chief characteristic of the prerogative state. And since the jurisdiction of the prerogative state is not defined, as we can tell by some of the acts that are now happening, where all of a sudden they just say, this not working. How's that? Is that better? Okay. Trump just comes up with different things, like we're going to have martial law in Los Angeles, or we're going to have the Alien Registration Act without publishing it. And so, and since the jurisdiction of the prerogative state, just making these claims, is not legally defined, there's no guarantee of the stability of the normative law. That is, we don't know what's going to happen because we don't follow the normative law when it comes to these absolute determinations. What's going on? Oh, you don't need this? Okay. Okay, let's see. Can you hear me?
Yeah.
Yes?
Good.
Okay.
That's good.
Franco gives numerous examples in this book, and I'll just give you one illustrative purpose and then turn to our Supreme Court decisions. A Jewish attorney had immigrated in 1933 from Germany after the government removed all licenses for Jews to practice law. He sought to obtain his birth certificate, presumably to establish his birth to the immigration authorities in his new country of emigration. The registrar under German law was absolutely required to provide the birth certificate. And the lower court judge said, yeah, he's entitled to his birth certificate and ruled in the lawyer's favor. The highest German court reversed, saying it was beyond the jurisdiction of the courts because the Gestapo had issued an executive order barring the issuance, and the registrar is bound to follow that order. The court has no authority to review the grounds for the instruction. And as I'll talk about, as you know, under the Alien Enemies Act, the question is ultimately going to be, does the court have the authority to review when the president says something that's patently ridiculous? We're obviously not at war. There is no incursion, but the president has said that. And the question is, will the court review it? So this is not all, theoretical and hypothetical. So this is what they call, and what he calls in the book, flipping the switch. In the normative state, usual legal principles would have required the issuance of the birth certificate, but in the prerogative state, the government intervenes, reversing the law, and the highest court says we have no authority to intervene because the government's decrees are beyond our jurisdiction. It thus makes all political decisions beyond the courts and creates instability within the court system because no one no longer knows actually what the rules of law are. So let's look at what's happening in the Supreme Court. The court is what they call in the court, and what we see happening now is what we call the shadow emergency docket, which I've now renamed the Trump docket, since Trump is the only one really going there on an emergency basis. And they've tried to avoid the ultimate concession that would make our legal system no different than Germany by not giving explanations for its decision. So my point is, the Supreme Court really can't decide ultimately what the heck they're going to do. And the reason, and so right now, they're really not giving any explanations for what they're doing, if you haven't noticed. So in Nome, let's take Nome versus Svetlana Doe. The district court issues an injunction against Trump's executive order, and the DHS follows up revoking parole to Cuban, Haitian, Nicaraguan, and Venezuelan citizens. You all know this. They've revoked the parole program. The district court, in a detailed 49-page order, relying on the proper legal standard, which for an injunction pending appeal. The Supreme Court says, stays the order, this 49-page order, without any word, okay, without a word of explanation, nothing. They just say, we, the Supreme Court, stay the decision. And, you know, there is a dissent, and the dissent says they botched the assessment. But what's the assessment? We don't even know what assessment was made because they never said anything. And that's an indication of their kind of instability about what the court is actually going to do when faced with these kinds of issues where there are executive orders by a president who they may or may not want to confront. In Norm versus National TPS Alliance, you know, that's the TPS case, taking away TPS from Venezuelans. The district court there entered an 85-page order on granting the plaintiff's claims. The Court of Appeals, following the proper standard under Niken, you know, the Supreme Court in Niken has set forth a standard which you can use to get a stay or not. And for those of you who practice, you know, sometimes you get the stay and sometimes you don't. And they always cite Niken as the standard under which you can get a stay. The Court of Appeals found that under Niken, a stay was not warranted. The Supreme Court simply grants Trump's stay without citation to Niken or any explanation. They just granted it. And then there's Trump v. Wilcox, which is even a more interesting case, which has nothing to do with immigration. It's where the president fires a member of the National Labor Relations Board and member of the Merit Systems Protection Board. And the members obtain an injunction in the lower court. In the normative state of the law, it has been clear for 90 years, based on Humphrey's executor's case, that the president absolutely did not have the authority to do it. The majority of the court, without even mentioning Humphrey's executor, grants a stay. And then in Trump versus JGG, the court avoids the obvious legal issue of whether the Alien Enemies Act applies at all and uses a procedural device to avoid ruling on the obvious question by not saying the AEA is illegal in this circumstance, which is, you know, I mean, you have to be kind of deaf, dumb, and blind, you know, to say that the AEA applies. I mean, even very conservative federal judges in Texas have said, of course it doesn't apply. There's no war, there's no incursion in the United States, and there's certainly no invasion. Those are the three criteria for the AEA, and yet the Supreme Court will not say, or hasn't yet said, that the use of the AEA was impermissible. And this is what I mean in talking about the prerogative state. They could have shut down all of this litigation on day one by simply saying the president didn't have the authority to use the AEA in sending anybody anywhere. They chose not to do that, and instead And it's so interesting, you know, when we read this stuff in the press, I'm always amused because they're always pictured as these great wins. And the lawyers, by the way, have done incredible work. And this is not to diminish anything they've done. In fact, in Immigrants List, we're giving an award to Lee Gallant, who did the JGG case and is an unbelievable lawyer. But the point is, instead of saying that the AEA is illegal, they determined that the plaintiffs filed the case in the wrong court and that they should have filed a habeas instead. Now, that's an obvious dodge for anybody who follows what the court does. And the same in AARP v. Trump, where they found that not giving sufficient notice to persons under the AEA, again, they could have just said the AEA doesn't apply. But then now they're talking about what quality of notice should be given to people before we send them to, you know, the modern day concentration camp in El Salvador, where we can give them notice of it first, which they, all of us know, are likely to ignore anyway. In AARP, where they found that not giving sufficient notice to persons subject to the Alien Enemies Act may be the court therefore dodged the obvious major issue where the improper use of executive authority may be challenged, therefore conceding the executive order's preeminence to the rule of law. Trump versus JGG and AARP is symptomatic of something that that is well known in the literature regarding the unitary executive. There are 6 members of the United States Supreme Court that believe that Article 2 gives the president have an all-powerful executive who would usher in autocracy, and an all-power executive who was like Trump. So it'll be interesting to see in the coming months whether Trump will pretextually use martial rule, as he indicated. cited for months. And then if you lose that, you appeal. Well, some courts have said, oh, you can't do that because you never appealed the underlying deportation order. And other courts have said, well, why would you appeal the underlying deportation order? There was no issue. The issue was with withholding only. So the withholding only cases, the asylum only, those cases where people want to appeal and the courts try and throw them out saying, well, you never appealed the underlying deportation order itself. That's the same thing that happened actually here in Monsalvo v. Bondi. The way the court did it is, they basically said he had no reason, which is true. The respondent had no reason to seek an appeal of the underlying deportation order because he'd been given voluntary departure. So he never appealed the underlying deportation order. And when his motion to reopen was denied, he appealed the motion to reopen denial. And the court said, yeah, you could say that there was no jurisdiction because he didn't appeal the underlying deportation order, but there was no purpose in appealing the underlying deportation order. He could have just appealed, as he did, the motion to reopen. So that's the issue also that will come up in the Riley case, because that's a case, again, of withholding of removal, the same jurisdictional issue. And I think they're having a difficult time with it, but they'll probably decide, I'd like to think they'll decide that you can appeal separately the withholding of removal or appeal, in this case, separately the motion to reopen without having to have made a meaningless appeal of the underlying deportation order. The next one was, how much time we got left?
We have 8 minutes left.
Okay. Oh, we got time. The next one is Lackey v. Stinney, which is not an immigration case. It's a 1983, 1988 case under the Civil Rights Act, but it will clearly have importance for, what we do in filing litigation. The court decided that the entry of a preliminary injunction, where the government then follows the preliminary injunction and the case is dismissed, is not a final order for purposes of getting attorney's fees. That's a big issue if you're a civil rights lawyer, right? You guys know. So the effect, I think, will be extremely harmful. I mean, if you look at the shadow docket, look at all of those cases, the Trump docket, look at all those cases, they're all preliminary injunctions. So the court's saying, if the preliminary injunction's issued and the government obeys the preliminary injunction, the case is over, you don't get attorney's fees. And there's a lot of attorney's fees in doing a preliminary injunction, as these two great lawyers know. It's not, most of the cases, the preliminary injunction. So it's a problem. And I think what's going to happen, as happened in other circumstances, they're probably going to apply this to the Equal Access to Justice Act, so that if you go into court on an immigration case and you seek EJIA fees, they're going to likely say the same thing. They haven't had a case yet, but they may. Okay, the next thing, although it's not on, it's not even on here, I think, is Martin versus the United States. And this is like my new obsession. And I'm going to talk about this at the Immigrants List panel too. I really believe that we as lawyers have an obligation now to start filing federal torts claim actions. And there's lots of political reasons to do that. There's lots of practical reasons. Federal torts claim basically says if a law enforcement officer engages in improperly an assault, battery, false imprisonment, false arrest, abusive process, and malicious prosecution, that you can sue them. They don't have sovereign immunity. And the issue is very, very important, because I think a couple of things are happening at the same time. Stephen Malicious in the White House is, attempting to force ICE officers to bring in 3,000 people a day. I mean, you've all probably heard this. And, you know, there's a lot of ICE officers who don't want to do it. That isn't what they signed up for. They didn't sign up. HSI didn't sign up to go and arrest somebody in a grocery store. The FBI, because they put everybody on it. They put the FBI, you know, they put DEA, they put AFT. All of those people are working on arrests for what you see in the streets of America now. And many of them don't want to do it. And some of them are very frustrated, and they're working 6.5 days a week. And so people make mistakes. And some other people just do it to be, you know, malicious. But most of them, I think, are, you know, pretty responsible people, and they make a lot of mistakes. And when they make those mistakes, you can sue them. And if we sue them enough, just like with the habeas, just like years before with mandamuses, if you start bringing all these federal torts claim actions all over the country, it's got to percolate up to the White House pretty quickly, because then they have to defend all these cases in federal court. They don't even have the resources to defend cases now because half of the Department of Justice is leaving. Anyway, so Martin is in the context of a federal tort claim case. It's an interesting case. It was a homeowner who brought an action because they raided the wrong house. You may have heard, this wasn't the case like the one in Oklahoma, but you may have heard of the Oklahoma case where ICE came in. They went into the house in the middle of the night. They dragged the mother out with the 3 kids in the rain. They took everything in the house. And then the next day they went, oops, we made a mistake. We went to the wrong house. So is that, you know, there's a question as to whether or not that is an action under the Federal Torts Claim Act, or whether or not the government could say it's a discretionary action. In this case, the 11th Circuit had this bizarre, the way the Federal Torts Claim Act works is it says the government has immunity, except for cases involving law enforcement officers. But then in those circumstances that I mentioned, but then it says also that there are all these other grounds to not allow a lawsuit. It's called the discretionary function exception to being able to sue or not. So this case really involved whether or not the 11th Circuit's own made-up rule, which was a rule that said some nexus furthering federal policy, is also an exemption under the Federal Torts Claim Act. They said that's nonsense. You know, they just made that up, which they did. The statute has 13 different categories, but they did say, which is not great, they said in the House case, the discretionary function exception could have applied, and we're sending it back to the lower courts to decide whether or not the discretionary function exception applies. There is a concurrence in the case. I think it was by Justice Sotomayor saying essentially we shouldn't apply the discretionary function in a case like this. It's pretty outrageous that they got the wrong house. That isn't what the Congress meant when they had and used discretionary function. So Martin versus the United States, it's also a good case to read to get you familiar with the Federal Torts Claim Act. And then I think we're almost at the end. I'm not going to talk about Martin's.
We have about 3 minutes left. Do you want to take a couple questions? Do you want to take a couple of questions?
Also, real quick,
Sure.
on the Federal Tort Claims Act, we added 2 slides late in the game, and they are in the slides, but they aren't in the packet that you have now. Check your AILA.org basket, and over the next week, the updated versions of everything will come through, and there will be 2 more slides in this slide.
So we have a couple questions for Ira here. One is, with the shadow docket, is it possible for the government to appeal directly from the district court, or do they have to still go through the circuit courts first?
That's a good question. I don't know. You may know. I mean, you two may know the answer. I'm not sure. They're supposed to seek a stay technically in the Court of Appeals first, and then go if the Court of Appeals doesn't answer fast enough, which is what I think happened in the AARP case. or no, actually they did answer quickly. They answer within 24 hours, then they can seek a stay in the Supreme Court. So, yeah, I think it's that progression, but it all becomes, the real issue here is, and this is why the number of justices complain about it. There's no briefing, there's no briefing in the way, and there's no real oral argument in the way that you would normally do it and take your time and do it the right way. It's just all state litigation, very quickly done and very quickly presented.
Well, yeah, because what we saw in this Florida case on the criminalization of basically being in Florida, Othmeyer, the Attorney General, he took it it hadn't been heard at all. But I mean, it was basically like they filed the appeal in the 11th Circuit and he went up to the SCOTUS. Just he didn't wait. But I don't know that he's an appellate expert.
Interesting.
I think that's all of our time. We're going to get the CLE code, and we apologize for the audio issues for the remote attendees. We've done our best today, and hopefully the recording will be available with all of the audio. So we appreciate your patience and your tolerance. And we're going to now hear from our day coordinator with the outgoing message and our CLE code.
Thank you so much, Brian, and thank you all for attending this session.